Good morning, good afternoon, good evening, depending where you are. Thank you very much for joining us today. I'm Ana Lucia Jacome, Senior Project Leader and Human Rights Expert. I work on aging and older persons issues at the Division for People and Social Inclusion at the UN Institute for Training and Research, UNITAR. I remain at your disposal in case you want to learn more about our initiatives and explore possible synergies. For the welcome remarks of the whole series, it is an honor to give the floor to Mr. Nikhil Seth, UN Assistant Secretary General and UNITAR's ED. Please, Mr. Seth, the floor is yours.
Ladies and gentlemen, it's a great pleasure for me to warmly welcome all of you to this second edition of the virtual roundtable series, Mainstreaming Knowledge on Aging. There are many facets for strengthening capacities on the aging process, which we wish to discuss today for the effective protection, the meaningful, free, and active participation of older persons in society. This goal concerns all of us. Increasingly, longevity is the result of the progress achieved in human development and health over the decades, and this global demographic change has made visible existing gaps in laws, in mechanisms, policies, and programs for protecting the older persons in the creation of a society for all ages. We will all get there one day. We may all experience becoming an older person firsthand or through one of our close relatives, friends, or colleagues who are getting closer to this stage of life. Given this reality, are we considering the quality of life throughout this journey? Leaving no one behind implies addressing different vulnerabilities, including those particular to the aging process. Last year, we took stock of the current situation of aging from several frontier issues, good practices, and challenges at local, regional, and international levels through existing mechanisms and initiatives in the framework of the United Nations. It was also an opportunity to learn about roles of states, national human rights institutions, civil society, academia, the private sector, and the work of the UN entities in the field. This year, we are going to focus on accessibility through the convening of 5 events starting today, and these will go on till November. These discussions will serve to better understand the core elements on issues like access to justice, access to labor markets, political participation, access to health and social services, culture and leisure services, as well as engaging different actors for a true multi-stakeholder approach to this issue that we are trying to address effectively. At the last year, human rights, the demographic worldwide scenario, human mobility, the digital divide, gender, labor, and health issues were discussed, and these will continue to be the bedrock of our discussions today. Ladies and gentlemen, this multi-stakeholder initiative is a contribution to keep fostering capacities in the framework of the UN Decade for Healthy Aging. We are grateful to all our partners, the CIFAL Global Network, so ably handled by Alex Mahia, UN DESA, UNFPA, IOM, UN Women, UNHCR, WHO, OHCHR, ITU, the Group of Friends of the Human Rights of Older Persons in UN Geneva, the Global Initiative on Aging Foundation, GIA, the International Network for the Prevention of Elder Abuses, the International Longevity Center, and the NGO Committee on Aging in Geneva. For all of those who don't understand the alphabet soup of acronyms in the United Nations, my deep apologies, but I can tell you that all these organizations are very much focused on the issues before us today. We welcome also to this initiative our dear colleagues from the International Labour Organization and the Harvard Law School Project on Disability. We strongly believe that joining efforts contributes to raise awareness and bridge paths for advancing aging issues in a truly comprehensive manner. At UNITAR, we closely believe on the impact of knowledge as a powerful tool for transforming the lives of individuals and through that of societies. It pursues the change of discriminatory social institutions, laws, cultural norms, and community practices. Therefore, The creation of spaces and initiatives to raise awareness, such as this series, represent an opportunity to enhance capabilities towards a culture of learning. I wish you all the best in the learning experience and encourage you to play a role in allowing the older person age with dignity.
Very much, Mr. Seth, for your warm message. We appreciate your time. Now, I give the floor to our moderator, Mr. Alex Mejia, Director of the Division for People and Social Inclusion. Please, Alex, the floor is yours.
Thank you, Ana Lucia. Thank you, Mr. Seth, for taking the time to set the tone and to welcome all of us. I will be very happy to moderate an impressive array of speakers from several organizations, Mr. Seth has already mentioned. But let me, in a very few seconds, just invite you, dear participants from all over the place, let me invite you to think, why is it that we have chosen this topic? And there we will have to, of course, ruminate and understand a little better. Why is it that access to justice is so important? We all know it is a basic principle of the rule of law. Its effective application envisages guaranteeing people to exercise their rights, as well as holding perpetrators in some cases and decision makers accountable. In the absence of the right access to justice, people are unable to have their voice heard. In this regard, older persons frequently face invisibility. This is a major problem that touches on many sides of the well-being of the aging population, mental health to begin with, but not only. There is also some lack of awareness of the rights, the obligations that exist, and of mechanisms that will allow us to indeed ensure access to justice. But perhaps where we try to fill a gap, we believe that there is also a lack of capacity and full understanding in several instances, national governments, subnational governments, local governments, practitioners, civil society as a whole, and we are trying to, of course, fill that gap. But to better understand this topic, I will have the privilege of introducing to you 4 speakers. And to begin with, I would like to warmly welcome Mr. Pradeep Wagel, Chief of the Economic, Social and Cultural Rights Section of the Office of the High Commissioner for Human Rights in Geneva. Mr. Wagel, the floor is yours. Welcome.
Thank you, Mr. Moderator, distinguished panelists, colleagues, friends, and participants. I'm very pleased to join you in this webinar on a critical issue that demands our immediate attention: access to justice for older persons. As you all know, international human rights framework provides that access to justice is a core element of the rule of law. It is indeed a fundamental right and an essential requirement for the protection and promotion of all other human rights. Older persons who have contributed their wisdom, experience, and efforts throughout their lives should not be denied the fundamental rights, which is right to access to justice when they need it most. The Universal Declaration of Human Rights provides in Articles 7, 8, 10, and 11 to be specific for the right to equality before the law without discrimination, equal protection under the law, the right to an effective remedy for violations of these rights, the right to a fair and public hearing by an independent tribunal. Similarly, the International Covenant on Civil and Political Rights recognizes these principles in various articles, in particular Article 2, 14, and 26. In this regard, the Human Rights Committee, which is the committee that interprets the rights and freedoms guaranteed by the International Covenant on Civil and Political Rights, provides that states are required to guarantee that individuals have accessible and effective remedies to assert their rights. Similarly, the International Covenant on Economic, Social, and Cultural Rights also recognizes that everyone has the right to an effective remedy be it judicial or administrative. A Committee on Economic, Social, and Cultural Rights, which is another body that interprets the provisions of the rights enshrined in the Covenant on Economic, Social, and Cultural Rights, states for an administrative remedy to be deemed appropriate, it must be accessible, affordable, timely, and effective. Furthermore, the Covenant on the Rights of Persons with Disability, which is the first international human rights instrument that enshrines the explicit rights to access to justice, calls for the elimination of obstacles and barriers faced by persons with disability in accessing justice on an equal basis with others. All these instruments, as you know, relate to access to justice, apply equally to older persons who are entitled to the same protections and guarantees in accessing justice as other individuals. Yet, millions of older persons across the globe are facing significant challenges in accessing justice and remedy for their human rights violations. Ageist attitude and practice are deeply entrenched in our society, including in the justice system, which prevent older persons to enjoy their rights. A significant challenge is that older persons may not be aware of their rights or the available legal remedies provided for them by law, either national or international. It is due to limited access to information and lack of education about legal processes. Financial constraints, including affordability of legal services and lack of free legal assistance, are often the case when older persons seek judicial remedies. Most older persons' income are very limited, which are inadequate and to address the range of cost associated with the legal system and access to justice system, making it very difficult for them to afford legal representation or access the necessary resources to seek justice. In this situation, poverty poses a significant barrier for older persons, especially those from developing and underdeveloped countries, as a considerable number of them, especially in rural areas, are living in poverty. Also, physical barriers and access to accessible buildings, transportation, and other public services prevent many older persons from accessing the court and legal aid. This is particularly problematic for people living in remote areas, as most legal services are available in cities. This situation becomes even more serious when older persons have kind of disability. Court proceedings, furthermore, are often not adapted to older persons' needs and abilities and do not provide reasonable accommodation. Digitalization, which is often cited as one of the most advanced requirements of our modern life, when it comes to older persons, it creates additional barriers for them because the submission of claims and documents in formal proceedings are increasingly processed electronically. In some cases, cultural norms hinder access to justice for older persons, particularly older women. They are often reluctant to resort to the legal system to resolve disputes, mainly because of notions of honor, shame, particularly regarding family matters such as inheritance of property, violence, and abuse. This year, OHCHR is commemorating the 75th anniversary of the Universal Declaration of Human Rights, the document that aim to eradicate hunger and promote freedom in the world. And this month in June, we are raising awareness of the key obstacles to women's participation in public and political life, which is necessary to improve older women's access to justice as well. Besides these barriers, there are some promising practices, which includes increasing awareness raising, courts giving priority to older persons to expedite proceedings provision of free legal assistance, mobile court, and community law centers in remote areas, and use of hotlines for older persons. Yet, essential elements of the right to access to justice remains ill-defined, too general, and not adequately targeted to particular challenges. To better address this problem, a comprehensive, dedicated, international, legally binding instrument on the human rights of older persons must be put in place to define all the elements of their rights specifically. Such an instrument should also define the normative elements relating to autonomy and legal capacity of older persons. In conclusion, access to justice for older persons is not just a matter of legal rights, but a testament to our society's values and principles. We must recognize the challenges the older person face in every part of the world and work collectively to ensure age-responsive laws, policies, processes, and provide them with support and resources they need to seek justice. By doing so, we will ensure a just and equitable society for all. Thank you very much, Mr. Moderator.
Thanks to you, Mr. Weigel, and allow me to do some justice to you because I did not mention at the beginning, and I apologize, that you come from Nepal, has served there as a public prosecutor, and now have a very successful career at the Human Rights Office of the High Commission for Human Rights for more than 20 years. Our respect to you and our appreciation for sharing your knowledge. I should mention that you have vast experience in the field in Cambodia, Sri Lanka, Gaza, Afghanistan, Darfur, and Sudan, in addition to working with the Asia Pacific section of the High Commissioner's Office with the Rule of Law and Democracy section. So it's been a pleasure to have you here. Thank you indeed for taking the time to join us in this to cover this very important topic. Now, may I go to the second speaker of this important webinar, and allow me to have the opportunity to properly introduce Commissioner Joel Hernandez Garcia from the Inter-American Commission on Human Rights of the Organization of American States. Commissioner Hernandez Garcia has been in this position since 2018. He is a member of the Board of Trustees of the UN Interregional Crime and Justice Research Institute and was a member of the Inter-American Judicial Committee. He is president of the Mexican branch of the International Law Association. In the Mexican Forest Service, he has also been ambassador and served in several positions. He is as well a professor of international law and international organizations. Commissioner Hernandez, it's a pleasure to have you with us. You have the floor.
Thank you. Thank you so much for having me at this important meeting. I want also to convey the warm regards of President Commissioner Margaret May Macaulay. She is the rapporteur for the rights of older persons of the Inter-American Commission on Human Rights. Unfortunately, she cannot be with us today, but she wanted to express her appreciation to all participants for their interest in this important topic. I want to thank the organizers of this event, and I also want to thank them for inviting the Commission. This event takes place at a special moment in which the Commission has just published its first report on the human rights of older persons and national protection system. The Commission's report is the result of a long process, and like everything that it takes time to mature, the report is a sign of the rooted commitment of the Inter-American system to the human rights of older persons. However, the concern and attention for older persons has been spread across different documents, reports, cases and jurisprudence, and international treaties within the Organization of American States bodies and mandates. In this sense, the report provides a unique guide highlighting the historical process of recognizing older persons as subjects of international protection, as well as the recent development of international standards to guarantee human rights, including access to justice. The report is structured into 5 chapters that address the main progress and challenges faced by the American states regarding the human rights situation of older persons. I invite you to review the Commission report on our website. The Commission's analysis regarding access to justice can be found in Chapter 4 of the report. In this chapter, the Commission addresses the international human rights standards as they are interpreted and applied to the situation of older persons. The Commission utilizes the American Declaration of the Rights and Duties of Man and other inter-American treaties, especially the Convention on Older Persons, to analyze the obligation of American states in favor of older persons. The information is analyzed and structured around various sets of rights. Before pointing out the main aspects of access to justice, it is essential to understand that all human rights obligations regarding older persons are crossed by the mandate of non-discrimination because of age, also known as ageism. And there are two standards that I would like to highlight. First, the principle of equality and the prohibition of discrimination has been recognized as a norm of jus cogens within the inter-American system. This includes age discrimination and the explicit mandate to prohibit intersectional discrimination. Accordingly, eradicating age discrimination must also be considered the confluence of other criteria that exacerbate the vulnerability of older persons, such as gender, ethnicity, racial origin, economic condition, and other factors. Second, the Commission recognizes that ageism is also a source of violence against this population group. Prejudices and stereotypes surrounding older persons, especially older women, concerning the alleged defenselessness due to supposed cognitive decline, their health situation, dependence, lack of autonomy, and reduced values as productive members of society, expose them to an elevated risk of being victims of violence. Taking this into account, when approaching the right to access to justice and older persons, it is critical to understand their exposure to discrimination and violence, because these are obstacles to exercising the right to justice. Multiple international instruments extensively regulate the right to access to justice in order to protect human rights. Organs of the inter-American systems have pointed out that the right to judicial protection entails the duty of states to provide an effective judicial remedy against acts that violate the rights of persons under their jurisdiction. The Commission has recognized that structural inequality restricts access to justice for specific segments of society, including older persons. In neutral terms, every older person has a right to a hearing with due guarantees and with a reasonable time by a competent, independent, and impartial tribunal previously established by law in the substantiation of any accusation of a criminal nature made against them, or simply for the determination of the rights and obligations of a civil, labor, fiscal, or any other nature. This is the starting point. However, reality shows that these guarantees require some adjustments to be enjoyed by older persons. Accordingly, the Convention on Older Persons combines various aspects involving the right to access to justice for older persons, such as respect for equality and non-discrimination, the importance of the time factor in judicial proceedings in cases involving claims or violations of the rights of older persons, preferential and differential treatment, the need for procedural adjustments, and training on the rights of older persons for personnel working in the administration of justice. Additionally, the issue of legal capacity is critical for older persons to access justice. Under international human rights law, states in the Americas have committed to adopt measures to provide the access to the support they may need to exercise their legal capacity, and to ensure that in all actions regarding the exercise of the legal capacity, appropriate and effective safeguards are provided to prevent them from abuse. These standards are not abstract regulations. On the contrary, the Commission observes that some of these guarantees are already in place in several countries in the hemisphere. I want to share some of these good practices with you now. Some states have undertaken measures to guarantee due diligence and preferential treatment for older adults in processing, resolving, and enforcing decisions of administrative and judicial proceedings. Also, legislation guaranteeing access to justice for older persons is contained in specialized norms of general nature, as well as in standards related to biodispossession, pensions, and retirement. Regarding programs for the judicial protection of older persons, the Commission has found that the care for other adults has been addressed in protocols with specific guidelines and directives for this purpose. It is also a widespread practice in the region to set up comprehensive care offices for older people. Information provided to us also accounts for prevention as a frequent practice in some countries in the Americas. Some countries reported that there is an alert system that informs justice operators of the existence of proceedings involving older persons, so that proceedings can move on a faster timeline. The presence of services for access to justice in cases involving undocumented persons, dispossession and mistreatments, as well as the implementation of measures to achieve closer contact between the prosecutorial investigation and the victims of crimes, including elderly victims of crime, are also present in the Americas. Let me finish. We're optimistic regarding the human rights of older persons and the incorporation of international standards at the domestic level. Inter-American jurisprudence is also moving the rights of older persons forward. From our point of view, although there is still a lot to be done, we see many pieces being brought together to protect and guarantee the rights of this population, the members of which have been long forgotten and invisible. I thank you for your attention.
We thank Commissioner Hernandez for sharing his knowledge and opinions and his expertise. Much appreciated indeed. And now it is my great honor to invite our next speaker. I would like to offer the floor to Madame Gladys Pickering, Executive Director of the Ministry of Justice of the Republic of Namibia. She has served this public entity for several years, including as Deputy Chief, Legal Services and International Cooperation, as well as lower courts and masters of the High Court. She was also legal attaché for human rights issues at the Permanent Mission of Namibia to the United Nations in Geneva. And among other experiences, she was the company secretary at the Namibia National Reinsurance Corporation and manager on trusts and states at PricewaterhouseCoopers. It is my pleasure to offer you the floor and welcome you, Ms. Pickering.
Good afternoon. Thank you so much for this fantastic opportunity to participate in this panel. Thank you to the UN institutions for the invitation to Namibia to participate. It is indeed an honor for us to share our experience on the ground in Namibia as far as access to justice for older persons is concerned. Of course, Namibia is a constitutional democracy, and we have our Constitution as the supreme law guiding us in all laws and policies that we enact on the ground in the protection of the rights of the people. Article 10 of the Namibian Constitution provides for the equality and freedom from discrimination of all persons in Namibia. Article 10.1 specifically provides for equality before the law, And Article 10 provides for various or sets out various grounds for non-discrimination in Namibia. Now, although age is not specifically listed as a ground for non-discrimination in Article 10.2 of the Constitution, it has become a very regularly accepted ground through our jurisprudence, set through our courts and other laws and policies in Namibia, that discrimination based on age is not tolerated and it is also not allowed. Now, in terms of access to justice, it is very interesting to note that in Namibia, we have a very youthful population, meaning that our older persons are actually almost a minority group in Namibia, and therefore protection of their rights and ensuring that they have access to justice is particularly important for us. And because Namibia is such a vast country with such a vast land size, it is also further important that we reach older persons in the rural areas, because they are the ones who are often neglected and mostly do not have access to the courts and to other institutions that will guarantee and promote their right to access to justice. Now, what I would like to focus on in respect of this topic for Namibia is that we have a very successful legal aid scheme in Namibia, and this has a very real and relevant impact on the right to access to justice for older persons, in that we have a specific provision in our regulations for the Legal Aid Act, that is Act 29 of 1990, where we require applicants for legal aid to make contributions. These are mandatory contributions that amount approximately to an amount of $18 per person for contribution to, or 17 euro to an applicant for legal aid. And this, our regulations provide that where a person cannot pay this contribution, especially if the person is a minor, a pensioner, which is in Namibia a person above the age of 60 years of age, a person in custody at a correctional facility or other detention facility, or a person otherwise unable to pay the contribution, then the director for legal aid has the right to waive the requirement for the payment of that contribution. I am mentioning this because in recent years in Namibia, we have experienced that more and more older persons apply for legal aid. And when we say older persons in Namibia, we refer to persons above the age of 60 years. 60 years is also the compulsory age for retirement in Namibia. And that is why general reference will be made to that age group. In terms of access to justice, our Directorate Legal Aid is mandated to provide legal aid at the expense of the state in civil and criminal matters to persons who have inadequate means to engage a legal practitioner to assist them. Now, as I've already indicated, pensioners, who are people over the age of 60, they are already exempted from paying the compulsory contribution to legal aid when you are a successful applicant. And over the past years, we have been granting legal aid to applicants over the age of 60 years in domestic violence matters, in maintenance matters, and I will come back to the maintenance issue just now as far as it relates to older persons, in civil matters where damages are claimed, or any other civil matter, especially, and this has become more prominent and more common in Namibia in recent years because of economic conditions, where older persons possess their own houses, they possess their own immovable property, but because of economic hardship, they have difficulty in paying their rates and taxes and also their municipal bills in terms of water and electricity. and they fall into debt. And where these houses are becoming the subject of a creditor's warrant of execution, where the property is attached to settle a debt, we have been going to court to ensure that the houses of older people are not attached for the settlement of debts, so that older persons are granted specific and revised payment plans where they fall into arrears on municipal bills for water and electricity, but also where they fall into arrears on payment of any other debt. Older persons are therefore safeguarded that they will not lose their property for the settlement of debt. This we do through the granting of legal aid to litigants over the age of 60 years. We also grant legal aid to litigants over the age of 60 years in criminal matters. And our correctional service facilities are specifically adapted to the needs of older persons when they are sentenced to custodial sentences. We grant legal aid in labor cases to older persons where they face disputes or where they are engaged in disputes with their employers or former employers, because at the age of retirement, they very often labor disputes arise with regards to the settlement or separation packages for these people who have reached the age of 60 years. We also provide legal aid for older persons in administration of deceased estates matters, where their spouses or children or any other person passes away and the deceased estate needs to be administered. Very often the older persons are then they are not dealt with in a fair manner when it comes to the distribution of the estate, and we grant legal aid to them to ensure that their rights and interests are protected in the liquidation of deceased estates of where they are the surviving parent or the surviving spouse. We further grant legal aid to older persons in divorce cases. And to that extent, we have also now a law reform process underway where we will make it more accessible for people, not just older persons, to access courts in divorce matters by granting divorce jurisdiction on our regional courts. Then where older persons apply for veteran status in terms of the Veterans Act of 2008 in Namibia, and that status is disputed because remember, many of our people in Namibia who are now older than 60, they have been part of the liberation struggle in Namibia for independence. And many of them have, they qualify to be listed as veterans because they have participated in the liberation struggle, but there is certain criteria to be met to qualify for that status. So that is often disputed, and we've also seen an increase in cases where we are required to provide legal representation for persons older than 60 years in those cases. As far as maintenance cases is concerned, the Maintenance Act for Namibia provides for children to care for their parents, for their elder parents, where the parents are unable to take care of themselves and in need of support or maintenance. That is then provided for in our Maintenance Act, and it specifically provides for the caretaking of older persons. Namibia also has a very progressive social network, net in terms of providing pension for older persons. So when the person reaches the age of 60 years, you immediately and automatically qualify to be granted a social grant by the government. That social grant is revised on an annual basis, and the government then updates or increases the amount as needed, and it is mostly inflation related. So we have a very good social net that takes care of the older persons. And for that, we have the social grant paid to all persons older than 60 years in Namibia. I would just like to conclude by saying we also have many challenges in respect of access to justice for older persons, in as much as we have the social grant, we have the Veterans Act, we have all the legal aid scheme that provides for specifically makes provision for older persons and how we can enable them to access the courts and to be taken care of during litigation. There are some challenges that also hinders full protection, promotion, and fulfillment of the rights of older persons. They also, inaccessibility of the legal aid scheme by older persons in rural areas remains a challenge because of the remoteness of the places where they live, lack of understanding of the processes, and our very often inability to, or not maybe inability, but also our lack of processes that are in place to enable them to understand their rights and the processes that they need to go through. That is a challenge because of the many languages also spoken in Namibia. So we need to communicate with older persons in a language that they understand and also in a manner that is understandable for them. And then we also have inadequate prioritization of cases involving older persons. To speed up the finalization of the cases, we often have to monitor that so that there is no undue delay. And as I've indicated, correctional services facilities, our courts, all infrastructure is it's user-friendly for older persons and persons with disabilities. And I would like to conclude at that. Thank you very much.
We thank you, Ms. Pickering. It's a pleasure to hear directly from a member state, in this case Namibia, of all these protections and practices that you have enacted throughout the years, and perhaps also on some challenges ahead. But quite an impressive array of services, and I thank you for enumerating and explaining them. Now, without further ado, it's also my great pleasure to invite Mr. Daniel Uribe Teran to take the floor. Mr. Uribe is the lead program officer of the Sustainable Development and Climate Change Program of the South Center, a very prestigious institution here in Geneva. He has wide experience in research, including on human rights, sustainable development, South-South and triangular cooperation. He supports and advises governments and civil society organizations in negotiations on international instruments. Previously, he served as coordinator of the Chambers of Case Selection of the Constitutional Court of the Republic of Ecuador, and also at the Ecuadorian Ministry of Foreign Affairs as a legal officer at the Division for Refugees and Migrants. Mr. Uribe, it's a pleasure to have you with us. The floor is yours.
Thank you very much, Mr. Mejia. Thank you very much to UNITAR and the UN entities for this great initiative and invitation of the South Center and myself to this important event. So first of all, I would like to highlight that population is aging. All of us are aging steadily and considerably. Life expectancy right now has increased to an average of 62 years old. So we know that we are getting old. That is something which is a fact. And therefore, it's important to know not only about what the challenges that we are facing, but also try to understand what is the potential to improve the life conditions for everyone, in particular through the access to justice as a tool that should be at the disposition of reach of all the persons. There is a need for promoting and encouraging all the persons' engagement with the judiciary, not only because it is an obligation of the state, but because the participation, and I want to speak here about participation of other persons, can actually improve the judicial systems, while also giving a role of all the persons in improving the quality of life and respect of human rights for all. So I would like to see this issue that you were raising in this particular workshop in three different levels. The first level is to see what is the benefits and the potential that other persons have when engaging with the judicial system. What have they done? What can they do? And how they are doing it. Then to identify some of the aspects that developing countries in particular has been engaging with respect to how to guarantee the right to access to justice of other persons. And at the end, just to highlight some of the challenges that we are currently facing that were already highlighted by the incredible panelists that I had before me, but that I would like to understand a little bit more on how they have been identified and how countries are responding to it. So on the first hand, let me try to start considering some of the developments that particularly developing countries have achieved in the progress towards granting truth, reparation, memory, and non-recurrence. So one of these elements was the establishment of the initiative called Mothers of the Plaza de Mayo, now Grandmothers of the Plaza de Mayo, which was an initiative recognized worldwide for its efforts toward finding missing persons, including children, during the Argentina dictatorship. So we know that during the Argentina dictatorship, there was a separation of families. And during that process, there was the establishment of a group that was called Mothers of the Plaza de Mayo. But something that is not really known is that the process, the judicial process actually started in 1977 by a group of grandmothers that were filing suits of habeas corpus requiring the state of Argentina to denounce missing children and suspend all adoption of children in Argentina, because there was a concern that these adoptions were actually carried out by children or to children or of children that were taken out from their family by the dictatorship. So the group of grandmothers at that stage in 1977, they started to visit courthouses, tribunals, and orphanages weekly, looking for their grandchildren, and also starting to use the system in order to put a stop, at least, to the adoption of these children that were separated by their families. But it wasn't until 1980 that the grandmothers actually started finding their children. And it was done through the use of the International Commission of the Inter-American Commission of Human Rights. They use this regional mechanism in which they can trust on just to start finding all of their grandchildren. So the group of grandmothers not only use the system that had in place, but they also kind of use the system for establishing a new law which was created which was adopted in 1980 that established the National Bank of Genetic Data with objective of restituting the identity of children that were illegitimately appropriated during the dictatorship. And using that law until now, until 2023, this has achieved the finding of 132 grandchildren that have recovered their real identity and also have joined the grandmothers and know what is their family and identity. So this is just one example of how the efforts taken towards granting access to justice of other persons can achieve the promotion of human rights, and particularly towards guaranteeing truth, reparation, memory, and non-recurrence. But that is not all. Another example is happening now. It's something that we are living right now. And it's the creation of a movement called the Senior Woman for Climate Protection Movement, which is a group of Swiss female pensioners that established and brought a claim against Switzerland in the European Court of Justice, arguing that Switzerland has not done enough in the face of rising temperatures because of climate change that have put at risk the dying, they have put them at risk of dying during heat waves. We know that Europe has one of the highest rates of death because of heat waves during summer. So this group has established a process right now in Switzerland and then into the European Court of Justice, requesting the Strasbourg Court to determine the right they have to be protected, and at the same time recognizing the obligation of the states, particularly richer states, to start having climate action with regards to their rights as older persons. This claim that was brought by the Senior Woman for Climate Protection has been followed by two other claims brought again by other groups in Europe and has been presented to the European Court of Justice, and they are now going into a fast track because of the imminent harm and risk of harm that the heat waves and climate change poses to older persons. At the same time, in the area of Latin America, for example, we have the case of Poblete Vilches versus Chile, where the Inter-American Court had the first opportunity to pronounce about the rights of older persons in the field of health. So in this particular case, the court recognized that there is a need to build national plans to address the issue of aging in a comprehensive manner that not only considers their vulnerability, but also the potential role for benefiting the whole of society. And for this, there is a need for states to enact legislation to facilitate access to social security systems, but also to judicial systems. It also recognized the need for special protection and comprehensive care in order to respect their autonomy and independence. And I think this is one of the major issues that this issue of the rights of other persons is trying to care about, is the issue of autonomy and independence. And because of this reasoning with the idea of autonomy and independence, there have been other kind of mechanisms that have been applicable. So when we see how participation and access to justice of other persons can bring important benefits for all, it is also necessary to see how there are experiences that warranty the access and participation to justice. So I would like to bring three cases in particular. One is the case of the jurisprudence of the Constitutional Court of Colombia that has considered other persons requiring immediate protection through the action of tutela. And in particular, the idea is to avoid subjecting them to procedures of an ordinary judicial system. So reducing the time, for example, of cases and allowing less complexity in the process. At the same time, for example, there are certain challenges in guaranteeing access to justice for other persons, including access to justice in rural areas, which was mentioned by Madam Pickering, but also the concentration of judicial services in urban centers and the digitalization of procedures, like was mentioned by Mr. Pradeep. So Argentina has responded to some of these challenges by instituting one unit, which is called the Unit of Mobile Public Defenders, to represent other persons in tribunals. But at the same time, other examples, for example, is that Dominican Republic, the judice has made a concerted effort to guarantee access to justice of other persons, including by reducing the judicial delays and limiting the complexity of judicial procedures. That is one of the issues which is more important. So they have recognized that by reducing the complexity of judicial procedures for other persons had a catalytic effect towards the reform of the whole judicial system and made the judicial system a little bit better. There are still some other issues that have to be added. One of them has been highlighted by Commissioner Hernandez with respect to structural inequality. And this is something that I would like to raise just as a final point before my time is finished, although I know that I have already finished. But this is one of the elements of concerns, which is that we cannot just speak about access to justice in an isolated manner. There are issues and obstacles which are in line with the structural inequality. So when we are looking, for example, to the digital transformation and digitalization of judicial systems and e-governance, for example, we have to understand that the majority of the population in the South doesn't have access to internet or doesn't have the necessary infrastructure to guarantee access to that kind of processes. At the same time, when we are looking at these mechanisms of digital transformation, the limitations that countries are facing with respect to energy transition are one of the most important ones. So when we are looking at this particular element of access to justice, we have to link those elements with respect to these structural consequences or structural challenges that countries are facing, in particular in the developing world. Thank you very much, Mr. Mejia, and thank you very much to all the panelists.
Thanks to you, Mr. Uribe, for giving us practical insights into what perhaps our audience would like to consider as very important aspects of what lies ahead of us. So allow me now to invite every participant to send us in writing your comments or questions. We will be happy to entertain them and to assign them to the speakers, but not before we go perhaps to the most enticing part of this digital gathering. It is truly a distinct pleasure for me to introduce Professor Michael Stein. Professor Stein has an impressive resume. He is the co-founder and executive director of the Harvard Law School Project on Disability and a visiting professor at Harvard Law School. When I have heard his name, it came no less than from the chairman of the Board of Trustees of UNITA, Ambassador Luis Gallegos, who expressed how much Professor Stein is indeed a world-renowned expert on disability law and policy. Now more and more also engaged with issues of aging. Now, it's important to mention to all of you, dear participants, that Dr. Stein participated in the drafting of the United Nations Convention on the Rights of Persons with Disabilities, a very unique multilateral instrument that has indeed certainly improved the life of people living with disabilities. Most of you perhaps have heard that there is a global impetus to conceive a similar process to try to get a United Nations Convention or treaty and agreement on the rights of the aging population, the aging persons. So his expertise is quite unique. He knows the United Nations very well, and it's such a prestigious academician at Harvard and beyond that is indeed a distinct pleasure to introduce him. So without further ado, Dr. Michael Ashley Stein will take the floor now. Welcome.
Thank you very much, Mr. Chair. I don't think I can live up to your kind words, but I can be grateful for them. Thank you for that. And thank you for preceding speakers who have illuminated many important points. I learned from you, and I appreciate that very much. I will speak with some reflections, and my short intervention will be reflections on what we might learn from the Convention on the Rights of Persons with Disabilities, CRPD, and its implementation, but also what questions we might have and some issues that we might keep at the front of our minds as we move forward. As the chair very kindly and correctly pointed out, I have the pleasure of working with Ambassador Gallegos first on the CRPD and now on the development of a treaty for older persons at the United Nations. And the impetus for both is that although older persons, much like disabled persons, were of course persons as far as universal coverage, they were not particularly included in UN programming, in UN policy. We've seen a dramatic, wonderful turnaround on behalf of the 1.3 billion persons with disabilities since the adaptation of the CRPD on the ambassador's birthday, December 13th, 2006. Inclusion in all of UN programming across all agencies, including the World Bank as a specialized agency, the creation of laws and policies across the world through the 187 states that have ratified the CRPD, although to my great regret, not yet the United States. And it is hoped that with the enunciation of a treaty for older persons, that we can see the same particular kind of focus, the same acknowledgement and recognition for those who are older persons, which my birthday is coming up in about 2 weeks, and I will be crossing that barrier along with some of you. When we think about older persons, we have to think about it in some ways the way we think about disability, in that demographically, numerically, the two cohorts have significant overlap. If you live long enough, you will have a disability. That's simply an epidemiological truth. And aging, much like disability, is a cross-cutting issue. It affects us across nationalities, across genders, across racial backgrounds, across all different types of backgrounds. And so both of them are intersectional, and we must always consider all the secondary levels of discrimination and opportunities for inclusion. Some of the preceding panelists have very rightfully pointed out poverty, rural status, and others as having a great impact. When we think about access to justice, for older persons, we're thinking in many ways about some of the same stigma and prejudice that preclude people with disabilities from adequately accessing justice. And one of the prior speakers was good enough to note the articulation of a separate article in the CRPD on access to justice, the first one in the international realm that does so. People who are older or who have disabilities face stigma in accessing justice based upon decreases in their ability to hear, to see, to recall events, to mobilize, to move. And now in the year 2023, it is also greatly impacted by information and communication technology, which is not to underestimate or ignore the fact that there is discrepancy in access to ICT across this very large globe of ours, and G3 ICT notes these in its DARE index, but that in many places, access to justice is increasingly via virtual communication, and that will have an impact upon persons who are older, both in accessing this communication and in using it. One of the tropes that we have about older persons, in this case myself included, is that they're at times can be unfamiliar with or reluctant to access technology. But going back to the bare essence, that of prejudice, we've seen through the disability sector the way that women and girls with disabilities who would bring cases related to sexual violence and abuse in many parts of the world would simply not be believed on the basis of, well, how could you identify the perpetrator since you don't see them? Or how can you provide evidence because you don't hear them as well? Or perhaps you don't recall it as well. Some of these terrible incidents were related in detail by former Special Rapporteur for the Prevention of Violence Against Women, Rashida Manjoo, my old friend, and we were delighted to support her report to the General Assembly on this. Much the same happens in the case of older persons relating to fraud, deceit, and other forms of abuse, including sexual violence, by the simple fact that judges, magistrates, referees, police, and others refuse to believe these accounts. So they are not seen, they are not heard, and they are turned away. In order to prevent this kind of exclusion, states must take dramatic efforts. To give you an example of a civil society-led effort, in Bangladesh, we had the pleasure of working with civil society to create forums in each of their provinces whereby people with disabilities were advised as to their rights under the national law, provided with legal aid assistance, and were able to go and to file complaints as to all forms of rights violations. I would argue that the same is necessary for older persons and across the globe, not simply in Bangladesh. But I'd like to pivot for a moment and talk about a large issue that was touched upon by some of my colleagues, and that is the issue of legal capacity. In bare legal terms, most people with disabilities across the globe have been subject to guardianship, which prevents them from an array of rights, including access to justice, as well as political participation, and even much simpler basic rights that we take for granted, such as being able to spend one's money or being able to enter into a contract. But if we're focusing on access to justice, the issue of guardianship is severe. Under the basic form, which is plenary guardianship, people with disabilities, older persons, and the group that overlaps between them are prevented from bearing witness in court, from proceeding with actions in court, from acting as witnesses or even defendants in court. And the CRPD has done a lot of great groundbreaking work as far as the general push towards shifting from guardianship and substituted decision-making towards realms of supported decision-making. But nevertheless, legal capacity, and this article from the CRPD has been at once the greatest controversial article within the CRPD. During the negotiations, it was the single most article that received the most pushback from states. In the realm of ratification, it is the single article that has received the most reservations, declarations, and understandings in opposition to it. And on the ground, although some states have adopted shifts from guardianship to supported decision-making, notably and very progressively Peru, many states and most people are actually at wit's end to understand exactly what does this mean in practice. And I'm not over-exaggerating in my declaration of this. We have had the European Court of Human Rights do 2 steps forward and 3 steps back on voting. We have had the Constitutional Court of Germany openly question the CRPD's interpretive general comment number 1. And if I'm being bluntly honest, there is a lot to that criticism. And what we have on the ground is a lack of understanding of how exactly do we move towards supported decision-making? What does it mean? Speaking on the ground and in a very micro level, here in the state of Massachusetts, we work with self-advocates with intellectual disabilities who have created their own supported decision-making contracts. Even though the state of Massachusetts does not have a law, and we in the US have now ratified the CRPD, they have developed their own supported decision-making contracts that we are disseminating and sharing with other groups around the world, but it's a work in progress. And to say that it is a simple work would be to devalue it. To say that having schizophrenia or an intellectual disability is the same as having dementia would be empirically incorrect. And we need to have research and thinking and experimentation in those realms to understand how we can best support older persons in making their own decisions with or without support. Understanding that there are times and competencies and areas in which they will want more or less support in making those decisions. And in doing so, we must always be very, very careful not to underestimate their capabilities and also to provide adequate support. To end on just one example, and I appreciated Commissioner Hernandez Garcia's examples from the Latin American region, but to provide one other one, before the CRPD was ratified, an Israeli family court judge issued an order that said that older persons were allowed to appoint their own supported decision makers, either from family or friends or otherwise. And that was a good start. The state has since changed their guardianship laws so that it's now supported decision-making, but more importantly, the Ministry of Justice has a separate division on older persons, which provides a lawyer who acts both as a legal aid lawyer and as a supported decision maker for older persons. And not only is that in terms of making their own decisions as to how to spend their lives, where to live, and so on, and to prevent fraud and to fight back against fraud and exploitation, but also as against the state itself. There's been a string of decisions in which older persons have told the state, no, I don't want to be put into an old age home. I want to age at home and receive supports. And so it goes both ways. And it's an interesting example, but it's simply one. And we need to explore these in much greater detail if older persons are to have adequate and protection and access to justice in a way that fulfills and promotes their human rights. So thank you very much for allowing me to intervene. I'm grateful to be with you. And I'll stop here so that we can dialogue with our participants.
Thanks to you, Professor Stein. Your wisdom indeed precedes you, and I appreciate this very holistic portrait of where we are, what needs to be done, and why the CRPD, the Convention of the Rights of the Persons with Disabilities, actually is an excellent benchmark for what needs to be done for older populations and older persons. Now, we have received several comments and questions on the floor. My colleague, Ana Lucia Jacome, here at the UN has helped me to tabulate some of them, and I will present some questions to each of you, distinguished speakers, hoping to get a very short rumination or reaction. But the first one needs an introduction. And allow me, this is, of course, for Mr. Pradeep Weigel of the Office of the High Commissioner of Human Rights. I need to say something for all participants listening from around the world, and particularly for the younger generation. We have seen the names and ages and the origin of the people that have registered, and I'm very happy to think that there are some young people also listening. And by the way, we get several hundreds, if not thousands, of people that see and watch the video of these proceedings ex post over YouTube and other platforms. But I need to introduce the first question. So, If we go to the basics, the Universal Declaration of Human Rights in 1948, that most of you will know, and I'm talking about discrimination. The preamble of the Universal Declaration of Human Rights actually says, and I'll read these few lines, is important. Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. And then several whereas, then, as I'm sure you know, Mr. Wabel, better than me, it says, now, therefore, the General Assembly proclaims this Universal Declaration of Human Rights. And then you have the whole list, right? I think most of us can remember the most important. But I need to tell the audience that immediately after Article 1, which is the most obvious, Article 2 is on discrimination. And I want to ask Mr. Walker what to do in practical terms to avoid discrimination of all the persons. But bear with me. Article 1 says all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. But Article 2 right there says, and I quote, everyone is entitled to all the rights and freedoms set forth in this declaration without distinction of any kind. And nowadays, this is pretty common to get to hear, but it doesn't say age. And that's where I want to go, Mr. Wagel. It says, no distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property views or other status. Furthermore, no distinction shall be made on the basis of political or international status of the country. And then at the end, it says, or under any other limitation. So we see that in 1948, our elders saw it very important to focus on the elimination of discrimination. But so very many decades later, we still see, and we still see it against vulnerable populations, particularly older persons. So, Mr. Weibel, a long introduction to us. You are the expert. Please guide us. What do we need to do to portray the Universal Declaration of Human Rights from that very specific angle, which is age, to avoid ageism? Back to you.
Thank you very much, Mr. Moderator. And it's not an easy question to answer, and it also goes to some of the structural barriers that we talked during this session. When I say structural barrier, there are legal policy issues. I think we spoke very much and in detail about the provisions, the challenges, and so on. So that's one. But are we doing enough to translate the provisions of the UDHR, the document that we all celebrate, and the document that has been 75 years old, the document of aspiration and the document of basis that led to the development of many other international human rights treaties, including that I advocated, that there has to be a separate treaty to regulate, to promote, to secure the rights of the older person. Not to say that we have not made progress, we have made progress. I think the reality in which the UDHR was drafted was slightly different than the reality we live today. We have had COVID pandemic recently, and the most who suffered were older persons. The demographic changes that we did not probably envisage well when we drafted the UDHR is posing us a new challenge. The states, the government, civil society, everyone has done a great job. I think we have to commend where progress have made. That's fascinating. But I would say two things. One, we have not done enough to look at what barriers were there, what barriers are there now, and how do we address them, and how do we use the human rights framework, not only the UDHR, but many other international instruments to address the barriers. When I say barriers, there are laws and regulations. In many countries, there's no dedicated law regulating the matters of older persons. The examples from Namibia was great examples. The examples of legal aid, the support, the language support, and so on. I was carefully listening. These are good examples where things are really progressing. But as we talk, there have been more poor older people than there used to be before. The global poverty rate has increased in general, and that also affects the poor people. So that's one barrier that we are seeing. Economic inequality. I think we spoke quite in detail about how economic inequality is affecting the world that we live now. And we tossed briefly, and one of the key challenges that we see is the cost of living crisis. I mentioned briefly in my speech in the beginning where there are rural poor, the pension not being enough to buy the food, and so on. I think that's one point. Second, have we adopted our institutions that enables the older persons to seek their rights and remedies? I think that's the question that I see. Of course, I could continue talking more about it. There have been also good progress. I think the inter-American system is something that is a very good example where other intergovernmental system at the regional level can borrow. And that's a good progress that we have to acknowledge. And that's one of the examples where things are heading to positive directions. But we need to do a lot. Thank you.
Thanks to you, Mr. Walker, indeed. Very much appreciated that you are taking this extra time. Now, my next question is for Commissioner Hernandez, and I'm going to read from the floor. It says the following. The Organization of American States has made a significant step towards the effective protection and promotion of the human rights of older persons in the Americas through the adoption of a specific convention. In this regard, could you share with us some highlights of its implementation so far? Commissioner. I think you're muted, Commissioner. Sorry. Still muted.
Yes.
Yes.
Good.
Welcome.
Thank you so much. That's thank you for the question that allows to elaborate on what the Organization of American States has done in the protection of the rights of older persons. And in fact, I think the organization has broken ground in adopting a convention on this subject matter. It was adopted on June 2015. The convention now is enforced. It entered into force in January 11, 2017. Now, what's the basis of the convention? The basis of the convention is that the condition of older persons must be addressed in a differentiated manner. It is the convention contains a catalog of rights for older persons. However, one of the important concepts is to avoid age discrimination in old age. In the former question, Mr. Mejia, you were asking about the factors of discrimination. And in the convention defines that age discrimination in old age as any distinction, exclusion, or restriction based on age aimed at or having the effect to restrict the recognition, the enjoyment, or the exercise of equal conditions of human rights. And on that basis, the convention elaborates on a set of rights which had to do with the promotion of human rights. It has to do with the dignity, with the equality and non-discrimination, one of the most important components has to do with well-being and care, also with gender equality. And with regard to the subject of this webinar, it also contains provision regarding effective judicial protection. So it's a set of rights that have been developed on the basis of the special nature of older persons in order for state parties to have a legislative basis in order to elaborate on their domestic, at the level of the domestic law.
Thank you indeed, Commissioner. This will serve well in the global endeavor to follow this example. The world needs a similar convention with a global scope. And I thank you for those comments. Now, to Madame Pickering, it was quite a unique thing for me, and I'm sure for all the participants, to get to hear from you the specificity of what your government has been doing to ensure that there are not only protections, but all these mechanisms of support for the elderly in Namibia. And we have received a question that goes hand in hand with that, but it's a little bigger than that. So please give us a continental view, if I may say. It says the following. In the framework of the African Union, what do you believe are the existing mechanisms on access to justice for all the persons, and what should be done? Ms. Pickering.
Thank you. That's a very relevant question, because as I said, as with Namibia, we have a rather youthful population, even at a continental level in Africa. We are the continent with, I think, with the biggest youth population. And therefore, the rights of older persons is something that is particularly paid attention to, because they are in the minority. In Africa, also, the mechanisms that are in place for protecting the rights of older persons is, of course, contained within the African Charter on Human and People's Rights. And that is our continental instrument that provides for the protection and promotion of human rights in general. Now, what is further of interest in Africa in respect of older persons is that there is, from an African perspective, a very great importance and value is attached to the wisdom of older persons. Because of cultural norms and how they transfer the cultural information, and also this is in connection with how we cultivate the earth and how we live in a customary setting. And in this regard, the indigenous knowledge of older persons in Africa is something that I think we should be paying more attention to, because of the fact that they possess so much knowledge of the continent and of the customs and the cultures on the continent. Also in respect of developments that relate to intellectual property on indigenous cultures and indigenous ways of growing certain plants, and it relates to so many things, including extractive industries and other economic activities, where specific activities take place within a specific setting, and where older persons are most often and most probably the best suited persons to advise on how this will impact on the lives of the communities. I think that is underrated in Africa from a continental perspective. But in general, in terms of the African Charter on Human and People's Rights, and specifically also in respect of women, when we have the where we have the Kampala Convention in Africa, those are instruments that we use at a continental level to ensure that our domestic laws and policies are aligned in respect of the protection of the rights of older persons and persons with disabilities, women and children. So we have excellent regional instruments, and at an AU level, we do report, as at the UN level. We also do report on the instruments at the certain periodical intervals. And we recently, last week, we had a visit by a commissioner of the African Commission on Human and People's Rights in Namibia. And she also raised the issues of what is happening to older persons, to women, to children at various institutional levels. So it is something that we, as the African continent, as Africans, we attach a lot of significance to older people because of the memory and the wealth of wisdom and information that they carry. So we need to make sure that that is carried over to the younger generations in an effective manner in order for us to also guard and protect the peculiar and special aspects of from an African perspective. Thank you.
Thanks to you, indeed. It helped us to think and try and understand how to what still needs to be done and how to emulate what has already been done. Now, let me go to Mr. Uribe, and then I will present a quite interesting question to Professor Stein before we run out of time. But to Mr. Uribe first, allow me to read a question from the floor. It says it's about the nexus between climate and the elder persons. It says the following: you mentioned the case of a senior women for climate protection. How can other groups with similar concerns bring cases on climate litigation or any other kind? Mr. Uribe, please.
Thank you very much. I think this is a very important question. There are two elements that have to be considered there. Particularly for climate action and environment protection, there have been interesting approaches and progress in different areas of the world, particularly in Latin America and Europe. We have this CASO agreement, which allows access to justice, guarantees access to justice and access to information, particularly for climate litigation and environment protection. And we have the Aarhus Convention in Europe that provides exactly the same kind of approach and protection. So the idea of using these kind of instruments to bring climate litigation and environmental protection, but also satisfying access to information of human rights defenders and also of older persons is an element which is important and has to be considered. There is one interesting approach which has been taken now, which is the ICJ consultation requested by Vanuatu with respect to the effects of climate action, which is being brought to the International Court of Justice. And there is one group which is called the Elders, which is a group created by Nelson Mandela that recognizes the need to discuss the access of justice and the necessity to identify the obligations of states with respect to this particular element. And there is, I think, where there is an important and potential of older persons to actually achieve this objective of protecting their right to life, particularly to the right to subsistence, because we always think about climate action just about the future generations, but we have to think about present generations as well. And presently, the most affected ones are older persons. So this is an element which is a necessity to discuss. And for this, I will just add, because I would like to just really go forward, that there is a need for creating capacity building, not only with respect to the legal rights that older persons have, but also how to empower them about the mechanisms, the means, and the tools they have to access to justice, not only at the national level, but also at the regional and international level. I think that, for example, Mr. Pradeb had mentioned the possibilities and the potential that this United Nations system has with respect to the UN mechanisms, for example. But there is, and in reality, there is a lack of consciousness about what the UN mechanisms can actually do, because people doesn't know about the potential of these mechanisms. So building capacity on that, continuing capacity, is an important element for this particular element. So thank you very much, Alex.
Thanks to you, Mr. Uribe. I couldn't agree more. The need to build capacity, it's of the utmost importance. But also thank you for your comments on the practical part, the legal instruments, the legal practices, and the right to justice, the access that the older person should have should be guaranteed at all times, and we should all be paying attention to that. Now, my last question for the day goes to Professor Michael Stein, but before I do so, I wanted to invite you to just visit the Harvard Law School webpage so you can see the list or part of the list of his publications. Particularly, I was discussing with Ambassador Gallegos, the chairman of UNITAD that I mentioned at the beginning, one particular book that Professor Stein published just a couple of years ago, I believe in 2021, on mental health, legal capacity, and human rights. I invite you to read this book, at least to learn a little about it, so you understand the intricacies and the delicacies of what really entails protection of the elderly, what really means to work, particularly when they miss their capabilities or they diminish their capabilities. What is it that society should ensure so they have right access to justice? But now, I'm going to amalgamate several questions, Professor Stein, but they ruminate about one thing, and this is the question. Based on your previous experience with the CRPD, the Convention on the Rights of Persons with Disabilities, what should we do to make this a whole of society effort? Because you see, Professor Stein, and you actually help us a lot. We at the UN, we preach to government, to government officials, to people and decision makers and policy makers and so on. And you know our work very well. You help us in the previous endeavor, global endeavor to adopt these landmark conventions on the rights of the person with disabilities. Now, for the new and most needed convention on the rights of elderly persons, what should we do to engage with everyone, not only with government, somehow with academia, sometimes with media, but particularly the youth, the whole of society? Give us some suggestions on what needs to be done so this is a whole of society approach, please.
What a wonderfully difficult and important question. Thank you. One of the great challenges that we have had has been in creating social movements that connect diverse groups so that everyone sees an enlightened self-interest, that this is something about them and not about someone else. And I cannot, in all honesty, say that we have been as successful or as we should, but your question is actually the answer, and that is to try to reach out to groups so that they understand that this is about their future as well as about their present. And your emphasis on youth is particularly important. Especially if we backtrack and talk about climate change, kids don't want to wait. Youth don't want to wait. It's their world. They're going to be in charge of it soon enough. And in particular, African youth, who in a number of 2 decades are going to comprise something like 50% of the globe's younger persons. So the demographics rule and the demographics dictate that they will need to think about this and hopefully see a buy-in and a value added, even if age or disability seems very far away for them. Hopefully it is something that they can think about looking forward to and wanting to have it be a constructive and empowering time for them rather than a challenging and exclusionary time for them. And beyond those very large words, I'm unsure of how one motivates and connects other than to sit down with stakeholders and have these discussions and listen to them with great humility and with great openness. We have to listen to the stakeholders, and your kind words about the book. What I like best about that book is 1/3 of the contributors are people with lived experience, and 1/3 are long-winded academics like myself, and 1/3 are the clinicians. And so actually having a dialogue between all relevant stakeholders and trying to see a common way forward, I think is always what we desire and always what all of us struggle with.
Well, thank you very much indeed. I actually asked you publicly to continue committed and to give us your help and guidance. You had a very unique experience on the CRPD. I do hope one day in a future webinar I can say that you're one of the few persons in this planet that has been partly at least responsible for 2 United Nations treaties. So I hope you can continue to help us and guide us and now for a global United Nations Convention on the Rights of Older Persons. Now, before we conclude, this has been a fascinating conversation for me. I thank all the speakers. I invite all of you listening, dear friends, and I can see how interesting it is because we have maintained more than 100 of you from 20-some countries listening all the way over 2 hours. That says a lot. But before we conclude, let me invite you on behalf of UNITAR, our UN agency at your service, to the next webinar similar to this one on the 26th of July on, of course, access to labor markets for older persons. It's everything about older persons. And we have this series of webinars that my colleague, Ms. Madame Ana Lucia Jacome, so efficiently leads. So with that, with our utmost appreciation to all the speakers again and to all of you participants, it is quite a beautiful moment to wrap up, inviting you to see the proceedings on the UNITAR YouTube page and to continue to engaging with us. Thank you very much. We wish you a good day wherever you are. All the best. Thank you.